Luigi Mangione pleads guilty. Why did he do it? Well, I believe he did it because he thinks it might get him out of prison while he's still in his 40s. Let me explain that. May it please the viewers, I'm Rich Schoenstein. This is So Sue Me. It's been a while, but I had to come back on to talk about this blockbuster plea of Luigi Mangione in federal court this morning. He pled guilty to 2 federal crimes: interstate stalking resulting in death, and the use of interstate facilities to commit stalking resulting in death. They are both stalking-related charges that obviously involve crossing state lines, and the particular sections of the counts at issue involve the death of the victim. So he has pled guilty to those. He will be sentenced in federal court in December. They said, I think, a December 18th date for sentencing, and his team immediately filed a motion in state court to dismiss the state claims against him on the grounds that they violate his due process rights and they would violate New York's double jeopardy law. So I'm going to get to all of that. Let's start with this. Why would Luigi Mangione plead guilty to anything? Number one, we assume he didn't think he could escape liability completely. We assume that his defense team thought the evidence that he committed a crime, that he is the person who killed Brian Thompson, was overwhelming. There's the stuff that was in his backpack, the gun, the notebook, the silencer. There's tracking of his whereabouts in the relevant days. There's probably DNA evidence. There's the video of someone shooting Brian Thompson. All of that was going to be brought into court. He probably thought that evidence was insurmountable. So a defendant facing murder charges tries to get the least penalty possible. And his defense team has already done a magnificent job in that respect. They got the death penalty eligible charges in federal court booted. They got the top terrorism related charges in state court booted. So they had already reduced this to potential life imprisonment, which is pretty bad, but they'd taken the death penalty off the table. And now my thesis is Luigi Mangione is hoping to reduce that even further. And let me show you how he's going to get there. And this is what I'm going to show you to do. Immediately following the guilty plea, his defense team filed in state court this notice of motion to dismiss the remaining second-degree murder charge and to dismiss the other counts because the dual prosecutions violate Mangione's Fifth Amendment due process right. In this filing, they talk about what is going to be the sentencing. I'm going to get to the strengths and weaknesses of the double jeopardy argument, but I want to talk about sentencing first because this filing is revealing. Counsel says in this filing that on the sentencing guidelines, they can represent that the federal government will take the position that sentencing for first-degree murder should be at level 43, the highest level recognized by the federal sentencing guidelines. That would be life imprisonment. And that, by the way, is exactly what the feds said at a press conference right outside the courthouse this morning. They said, we're going to seek life in prison. We're going to seek the highest possible penalty. But as this affirmation goes on to say, you reduce that level 43 punishment by 2 levels because he entered a guilty plea. And then they're going to ask to reduce it by an additional point because he did it sufficiently in advance of the federal trial, which wasn't scheduled to start next year. And then they're going to argue he has no criminal history. He has no criminal history points. He's in a criminal history category of 1. And the result of that is guidelines suggesting in between 292 and 365 months. Here are the federal sentencing guidelines. You can find them online. And you can see at the bottom here, these categories 40 through 43. Category 43 is life in prison. That would be the baseline penalty for the 2 counts Mangione pled guilty to. But if you reduce that by 2 points, and then if you reduce it to a third point, you get to category 40. All right, so I've made that a little bit bigger so you can see category 40 has, for a criminal history category 1, 292 to 365 months. And to put that in perspective, that is basically 24 to 30 years. Now, under the federal system, there's no such thing as parole, but you can get credit for good conduct in prison. You can get credit and reduce your penalty. You have to serve at least 85%. So if you have a 24-year prison sentence, you have to serve at least 20 years. But that could ultimately be your sentence. So under these guidelines that are being proposed by the federal government and I guess by Mangione's defense team, the penalty in the federal case could be as little as 20 years. And keep in mind, he's already served 2 years. He's been in prison for 2 years. They'll want credit for that. So think about this for a second. He could get an 18-year prison term, which would have him out of jail in 2044 when he will be 46 years old. And that may seem like a long prison term to somebody who's 28 and facing the rest of their lives, but I'm a little older than that, and it doesn't seem like that long under these circumstances. He could be out of jail in his 40s. In his mid-40s, he could be out of jail under what has been pled to here. That is the central motivation. And by the way, that term will be spent in a federal prison, not a state prison. And that's a substantial inducement to a defendant facing federal and state charges that you can end up in federal prison, not state prison. So he goes to federal prison, maybe for as little as 18 or 20 years. He avoids a federal trial. He avoids the expense of that. He avoids the focus that a trial would put on the specifics of the killing and instead has a sentencing hearing where everybody talks about him, how he has no criminal record, what a great guy he was, how smart he is, how he cares so much, the pain he allegedly endured because of his back injury and his struggles with the healthcare system and why he committed these crimes. You keep the focus on the whys and on him rather than on the how of the crime, and you try to get the minimum sentence possible. And at the same time, of course, they are moving to dismiss those state court claims. Well, let me talk a little bit about that. Okay, I'm going back now to the motion and the attached affirmation from Karen Friedman Agnifilo. This is a 32-page affirmation in support of the motion to dismiss. It is very well researched. It is very well written. Obviously, it was prepared in advance of today. They didn't just whip this up this morning and file it in court. They are arguing essentially two things. They're arguing that the charges should be dismissed because of due process violations, and they're arguing that the charges should be dismissed under New York's double jeopardy law. And then they get into a discussion, as you see in the index here, about whether the exceptions to the double jeopardy law apply. I'm going to briefly go over both of those arguments. Mangione's due process argument says there never should have been two prosecutions in the first place. It put an undue burden on him. And they focus on the fact that he couldn't pursue certain defenses in the state case because he faced a federal trial down the road. And I think what they're talking about is this extreme emotional disturbance defense. Remember, the possibility was raised that Mangione was going to offer psychiatric evidence, expert testimony that he was suffering from extreme emotional disturbance, and that was a potential defense that in the state court system would reduce a murder count to manslaughter. But the problem was you essentially concede guilt, and there is no extreme emotional distress defense in federal court. So what the defense team is saying now is we had to bypass the EED defense. We couldn't use it in state court because it would have impaired his rights in federal court. And the whole way these trials were structured purposefully to have the state case go before the federal case violated his due process rights, and the state charges should be thrown out on that basis. And then the second thing they're saying, of course, is it's double jeopardy. He's pled guilty to federal charges, and you can't now try him for the state charges. And the key there is going to be whether those charges under the New York statute overlap significantly. Just real briefly on double jeopardy. I mean, I could spend a long time dissecting the legal argument here, but to focus you, there's an exception under the Criminal Procedure Law section 4020. Here it is, the CPL in New York. It says, sub 2 here, a person may not be separately prosecuted for two offenses based on the same act or criminal transaction unless, and then you look at sub B. Sub A doesn't apply. You look at B. Each of the offenses as defined contains an element which is not an element of the other, and the statutory provisions defining such offenses are designed to prevent very different kinds of harm. Now, even the papers filed by Mangione's lawyers today concede the first part of that test. The federal charges in this case are about stalking. They have elements involving stalking and interstate travel that aren't part of the state charges. And the state charge has intentional murder. So that has stuff that's not part of the federal charges. And everybody agrees there are elements that are different. So the focus is going to be on the second part. Are the offenses designed to prevent very different kinds of harm or evil? The defense is going to say, no, they're both about killing. One's about stalking and killing. The other is about intentional killing. But the bottom line is both the federal charges and the state charges are about killing. That is essentially the same kind of harm or evil, and it's double jeopardy. The prosecutors are going to argue that they're quite different. The federal charges are about stalking and interstate travel. That is a separate evil from intentional murder, which is in the state charge. And so the state prosecutors are going to argue in response to this motion that it's very different and the state charges can go forward. I expect that the state court's going to have to move back the trial to allow this motion to be fully briefed and heard. The trial is supposed to start with jury selection on September 8th. I would think that the court's going to want the prosecution to put in a brief, the defense to put in a reply brief, to hear oral argument, to do its own research, to issue an opinion. They can't all do all of that by right after Labor Day. That's just not doable at this point. So I expect those dates to be moved. But this double jeopardy argument, I think, is an open issue. I think it's debatable. I think it's going to be hotly contested. There is no case directly on point. I know everyone talks about this Paul Manafort case, and actually Mangione's lawyers attached that decision to their papers. Paul Manafort had a situation where he was in federal and state court, but they were fraud charges in both courts, right? The state had mortgage fraud claims and the federal government had bank fraud, and the court essentially found that that's the same thing, mortgage fraud and bank fraud. I think that's a little bit different than the scenario we have here where there's stalking, interstate stalking resulting in death, and intentional murder. I think it's a different analysis. Now, it may come out the same. I'm not really sure which way it's going to come out. I haven't read all of the cases on the issue, but I think it's close, and I think it's going to be considered by the court. There's a pretty good chance it'll end up on appeal. But that is the issue. So let's just back up for a second. Why would we've talked about why Mangione would do this. Why would the federal government agree to it? Well, first of all, the federal government doesn't really agree to it. I mean, Mangione came in and accepted a plea on his own. There isn't a deal per se. As I said, they don't agree on sentencing. That gets determined by the judge. There certainly was a discussion, And I'm sure the feds knew this was happening. And I bet there must have been a discussion about that point system, that it would be life in prison, but he would get 3 points of benefit, which would take it back to somewhere between 24 and 30 years, with time off that could be somewhere between 20 and 25 years. I'm sure that was discussed. I know the federal prosecutors came outside of the court today and said very sternly, we're seeking life in prison. That's technically true, but everybody involved knows how this point system works, and it's not going to be life in prison. So the federal government would do it, number one, because they don't actually have a lot of choice. He can plead guilty on his own. Number two, to avoid the cost and expense of a trial. Number three, for certainty, because there is some concern about juror nullification. So if you're the prosecutor, you had to have some concern about going to trial and facing a jury that could have Mangione supporters on it. And then lastly, I don't imagine the federal prosecutors are upset that they might have undercut the New York State prosecutors. These two groups have not worked together from the outset of this case. It's been a problem. There is, of course, an adversarial relationship between the federal government and the New York State District Attorney's Office. Those two do not get along. And I would think that the federal prosecutors were only happy to reach a conclusion, no matter what effect that would have on the state prosecution. That is somewhat supposition, but I think it's pretty clear from the facts. For the state prosecutors, this has to be a gut punch. They're less than a month away from trial. They're ready to pick a jury. They have their charges loaded up. They're ready to go. And now they may not get to. Now, there are still weapons charges and false identification charges in the state case. And by the way, in Mangione's papers, they say that the firearm charges have to be thrown out too. They have a whole justification for that. And I don't know if anyone would bother trying this case just on firearms or just on false identification. Lastly, this has to put some pressure on the New York State prosecutors to reach a resolution of their own. The case has been resolved on a federal level. People will ask, why is the state government still prosecuting, if only to get a slightly bigger sentence? And that would be the answer. They don't like the sentence that's going to be imposed by the federal government. They want more punishment. They're going to go forward. There'll be some pressure on the state to resolve it on their own. I don't know if they will, especially given that political interplay I just mentioned. There you have it. Just short, a little bit stream of consciousness on what we saw today. I just wanted to get this recorded and get it up for you all. I will be back with more. This is still a developing story. Really interested to see this double jeopardy motion move forward. Thanks so much for watching. We'll see you soon. For now, we are adjourned.